which parts of the Charlie Hebdo magazine would have been illegal under our laws?
Well, what we have with Charlie Hebdo is hundreds, if not thousands, if not millions of images and cartoons designed to mock and to ridicule people. And some of them would have come in violation of Section 18C of the Racial Discrimination Act, which makes it unlawful to offend or insult people. And there's no ambiguity about that. Many would be able to be published, many would not be able to be published. And this is one of the great challenges we have with the operation of this law, is it sets a very low bar in restricting free speech, and a bar which doesn't exist for any other issue or any other group within the community apart from on race.
Wasn't that the very point of the magazine, though, to challenge? I mean, it was very challenging in France, and we saw the backlash to that, obviously, in the lead up to that horrible attack last week.
Well, I don't think violence is ever a justification against people expressing an opinion, even if it's through humour. The simple reality is people were drawing cartoons. Yes, they were designed to challenge. Yes, they were designed to mock people. Well, what's wrong with that? We live in a free society, and people should be free to stand up, to challenge, to mock and to ridicule people that they disagree with. And the solution to that is actually to respond with words, to respond through discussion, to highlight the stupidity of people's positions, or to put up counter-arguments. The solution is not violence, but equally the solution is not censorship. And that is what we have, at least in part, for some of the images in Charlie Hebdo in Australia, and that should be removed.
All right, so we do have a strong culture of satire here in Australia, our own brand, be it Norman Gunston or The Chaser. Are there other forms of satire that you know about at the moment that are being censored and deserve a run?
Well, the reality is that restrictions on free speech rarely end up in something being censored. What people end up by an official regulator or a government agency, what tends to happen is people self-censor because they don't want to get drawn out into long and potentially court battles and costly court battles, or want to face the consequences of what happens if they come in violation of a free speech restriction on something as simple as offender insult. But throughout the country, I've heard continuously as I've gone around people who feel that their free speech is being restricted, but equally questioning why it is that there is this standard that applies to race that doesn't apply to everybody else within the community, and thinking there is a need to broaden the operation of this law, but also raising the bar because the bar is simply set too low. The advocates in support of this law need to tell us why it is that it should be unlawful to offend or insult people on the basis of their race or national or ethnic origin, but why it's entirely legitimate to do that for people on the basis of their sexual orientation, and why there can't be equivalent provisions for that. And the answer to the last question is rhetorical. It's because it would mean censorship of priests, of rabbis and imams if they simply wanted to say that homosexuality was immoral. And so we cannot have a standard that applies to some and not others.
Fair enough. And yet the fact is that these are the laws as they exist. Surely any change that comes, the people who are advocating that change really need to convince people of the reasons to do so.
Well, absolutely, and what we've seen in the past couple of days is the rhetorical commitment to free speech. But at the same time, we've seen too many people say, we support laws that make it unlawful to offend or insult people. You can't talk the talk and not walk the walk. And that's what we need to see. This law has some significant failures, least because it makes speech that is offensive and insulting unlawful, but it isn't even in line with the recommendations that came up that preceded. Prior to the introduction of this law, there were 3 significant federal inquiries. All 3 recommended introducing a provision around public harassment on the basis of race, which is broadly what I support. 0 of them recommended the current laws in place, and one of them specifically, the Human Rights and Equal Opportunity Commission, explicitly warned against it and said that this would lead to situations where free speech was being censored.
All right, now look, I've only got time for one more question, but I mean, you're starting this debate again in 2015. I wonder though, as the opposition leader Bill Shorten has suggested, that it's distasteful to have this debate in the context of the Paris terror attacks.
Well, what's distasteful is to see politicians standing up and saying proudly that they support free speech and that Charlie Hebdo was a wake-up call to the world, and therefore they strongly support free speech, but they're not prepared to actually preserve it in Australia. That is crocodile tears to seek to advance their own political interests rather than standing up for the principles that they claim they believe in.
All right, Tim Wilson, thank you very much for your time.
Pleasure.